With this, we move on with the panel number 1, which debates on avoidance precedes resolution, entering an era of dispute avoidance. I would like to request the moderator for the session, Mr. Aaron Dowlung Hussey, who's a barrister at 4-5 Gray's Inn, Square Chambers, and also serves as a junior vice chairman at the Adjudication Society, London. He will be discussing and sharing his thoughts on the efficacy of dispute resolution and adjudication boards in construction contracts. Our first speaker in this panel is Mr. Ijaz Ahmed, who's a partner at Ijaz Ahmed and Associates, and will be discussing his thoughts on the impact of multi-tier dispute resolution clauses. Our next speaker is Mr. Shahab Sarki, who's a partner at No.1 Sarki and Co., and will be discussing his thoughts on the evolution and impact of dispute avoidance adjudication boards. The next speaker is Mr. Salman Iqbal Bhavani, who is a partner at Bhavani and Partners, and will be discussing his thoughts on the effectiveness of dispute avoidance mechanism in listed securities trading market and mutual fund industry in Pakistan. Our second last speaker in this panel is Mr. Ghulam Abbas Shupa, who is the Registrar for Gilgit-Baltistan Chief Court, and will be discussing his thoughts on risk management strategies for dispute avoidance in energy sector. Our last speaker in this panel is Honorable Mr. Justice Ijaz Anwar, who is the Senior Puisne Judge of the Peshawar High Court, and will be discussing his thoughts on integrating dispute avoidance in Pakistan's court system.
Thank you. I'm very grateful indeed for the invite from the organisers to attend today, and it's a great privilege to be in Karachi for the first time, having previously visited other parts of Pakistan. So I am indeed a barrister at 4-5 Gray's Inn Square in London. I'm normally very keen to point out, however, that I'm Irish, and I might not do that today because it's very hard to explain how strange it is for an Irish person to have to talk about cricket. So hopefully by the end of the one-day series, the results may be more as you would expect. So I'll gloss over that, and in the nicest possible way, if you could avoid bringing it up with me afterwards if you're talking to me, because I don't know the slightest thing about the sport. But in any event, I'm conscious of the very experienced panel here today that for many of you will need no introductions. So I'm going to, with all respect, not spend too many moments telling you what you probably already know about them, and just try and move the session on towards the content and hopefully some time for questions. So the theme running through the session is obviously the importance of dispute avoidance, which is often overlooked. So the panelists look at dispute avoidance from a number of different areas. So Mr. Ahmed, who's obviously a very senior lawyer in Karachi, will open by looking at oil and gas contracts, the scope for ADR. Thank you.
Thank you, Aaron. I think I'll just give a very high-level overview of the sector first, so that we can understand what is really the context of what we discussed in terms of dispute resolution. So basically, globally, the oil and gas sector is divided into three segments. That's upstream. These are the exploration and development companies. And then there are midstream, which are the refineries, and then there are downstream, which are the oil marketing company, the gas distribution companies. The type of contracts that we have, because it is a regulated sector and the government is the owner of the mineral resources. So in the upstream sector, we have prospecting licenses, concession agreements, leases, and joint operating agreements. The first three are obviously with the government and the exploration companies. The fourth one is between the working interest owners, who are the partners in a particular project. And then the kind of dispute resolution that you have at the moment is there is government regulation, and then there is arbitration in terms of all of these agreements. This arbitration is slightly unique from other dispute resolution clauses. It first provides for an ICSID arbitration if the working interest owner is a foreign entity. If for any reason ICSID does not take jurisdiction, then the matter can be referred to ICC. But if both the parties are domestic, then it is a domestic arbitration. That presents its own challenges, but we'll talk about that. If you can please move on. Then in the midstream, it is generally contracts between refineries and E&P companies. The government has an involvement there as well, because the allocation of the resources that have been explored and developed is within the control of the federal government. And then the contracts between E&P companies and refineries for the crude supplies, they generally contain negotiated arbitration clauses, so there is a large variety of them. And in terms of finished products, again, because these are negotiated contracts, again, there is a variety of arbitration clauses that they go by. But with the midstreams and the downstream, the other change is that there is now a regulator, Oil and Gas Regulation Authority, which has one of the functions is to resolve disputes between the licensees. And the midstream and the downstream sector need license to operate in Pakistan. So as a result, you have a regulated dispute resolution process available as well. So if we move to the downstream, that's essentially the distribution. Now, OMC is that the oil marketing companies for the liquid fuels, and the gas distribution for the gaseous energy. They have bulk consumer and retail consumers. In the gas sector, there are very few bulk consumers. Normally, the large industries are also treated as retail consumer. The bulk consumer were actually the powerhouses which are being supplied gas. There again, negotiated arbitration clauses, but mostly provide for foreign arbitrations than local arbitration. With the retail consumer, the dispute resolution process is with the regulator, but a large number of them end up in courts as well. In the first half, there are very few disputes that end up in courts. But the unique thing about oil and gas sector is than most of the other sectors, the government is not only the regulator, but the government is also a competitor, because in each of the three segments of the oil and gas sector, either the government is undertaking business directly or through what we call state-owned enterprises that are companies mostly listed on the stock exchanges, but they are controlled by the federal government, and we have statutory framework where the government can take policy decisions and undertake some guidelines to resolve the dispute. And that presents a challenge and an opportunity also. I think most of us in Pakistan would have heard about circular debt. That is a classic example of a challenge and opportunity at the same time, because the way circular debt arises is when the government does not pay its electricity bill, the electricity company does not pay the gas distribution company for the gas distribution company does not pay the exploration company for the gas it has supplied, and that's why it's called circular. And it is growing, unfortunately, at a phenomenal speed. This has not ended up in any court as yet, because the government continues to work on a resolution. But unfortunately, that resolution is not coming around for the reason that all the public sector players in the oil and gas are willing to listen to whatever the government is saying and just go along. And that is not for their compliance. That is simply because nobody wants to take a decision, because if they take a decision, then they will have to be accountable. And the private sector players, unfortunately, are the ones who continue to engage and find the resolution, but they haven't been because the size of the issue is phenomenal. The last reported figures of circular debt only in the energy sector is about 5.72 trillion rupees. So there, I think, where the this opens the opportunity for a statutory framework for mediation. Because for the public sector, the biggest problem is to take a decision and take responsibility for the decision. And that is the reason that most of the public sector disputes that end up in the courts, they go all the way up to the Supreme Court, and unless everything is exhausted, they will not implement anything. But if we have a mandatory statutory mediation arrangement where experts can help bring around a solution, that might make life easier for the public sector. The government has just taken one such step, that in taxation cases now, there is a mandatory alternative dispute resolution if the assessee in a tax claim is a public sector organization. And I think there is something similar that if it is introduced in the oil and gas sector, that might also be helpful to resolve a number of issues. And that is particularly so because most of the disputes in the oil and gas sector are also very technical in nature, and therefore for the normal litigation to resolve that issue is extremely challenging.
Do you see any current or future role for arbitration and mediation together? So what's often called escalating dispute clauses or multi-tier dispute clauses?
Yeah, the two things where it can help, because for example in the upstream sector, the government and the energy department acts as an informal regulator, and most of the time they are unable to come up with a solution that is helpful for both the parties. This being a public sector authority, any decision that anybody does not like gets challenged in the court. But if they introduce a mandatory mediation at that stage, that might help to not only to resolve the issues, but then also not bring the disputes to the courts.
Thank you. I'm conscious of the number of panelists and the time, so we'll keep going for now and then maybe come back if we're able for additional questions. And the organisers were kind enough to suggest that I might have said something in my opening on dispute avoidance adjudication boards. I didn't. I don't propose to. Mr. Saki, who's the next speaker, is covering that. And again, he will be very well known to most of you, a senior lawyer in Karachi. And apologies, I don't know if you're the current president of the High Court Bar Association or last year's.
Yes, thank you. I'm not the current president of Sindh High Court Bar. I'm a member of the Pakistan Bar Council currently. I was a former president, and thank you very much. Yeah, thank you. I was going through this DABs and DAABs, as they are called, dispute avoidance boards and dispute avoidance and adjudication boards. And I was thinking there are already so many tiers in place. There's mediation, there's arbitration, there's MEDARB. And so what was the need of, I believe when I was reading it up, it happened sometimes in the 1950s or 1960s in the United States, where there was a dam which was being constructed. And I believe the conceivers of this, they came to the conclusion that even arbitration is subsequent to it. So let us keep something before that so that disputes could be avoided instead of going into mediation or arbitration. So they conceived this, I don't remember the name of the dam, but it was a project of a dam. And from there, the dispute, it was a success, and therefore it continued. There was a dispute avoidance board. Now there is also a dispute avoidance and adjudication board. And it is very interesting. I think the theme of this topic should be that time is of essence, time is money, time is of essence. The need for this is because in big construction projects, dams or multi-million-dollar projects, construction projects, if you delay it by even a few days, the cost escalation is very high, number one. Secondly, if you delay it for a month or 2 months, it gets delayed, then it is very difficult for it to restart. And thirdly, the legal cost in some cases is almost 8 to 10% of the overall project cost. So to avoid all that, the Dispute Avoidance Board and Dispute Avoidance and Adjudication Board were introduced. Now the board could be consisting of, in small projects, 1 person, and in bigger projects, 3 persons, 3 qualified persons. And one thing I would say on the side, that whenever the mediation, the topic of mediation, arbitration, or dispute resolution comes up, I am a professional litigator, by the way. So most of the lawyers have this query: you are taking away our work, and this is going to take away litigation. So my message for them is litigation is never going to end in this world. So the courts will function, the lawyers will function, the judges will function, don't worry about that. But this is important for 2 reasons. One, the courts, especially in Pakistan, are like, their docket is completely full. In fact, more than full. So the proper matters which need adjudication and litigation in the courts of law, they are not getting due attention. If these matters are resolved earlier and they do not come to the courts will be free to work on constitutional matters or on matters for the purposes for which the courts are there. So these matters will go away. Secondly, the lawyers are not going to lose their income. The lawyers, because in the dispute resolution board or dispute adjudication boards, there is room for lawyers. For example, in construction industry, somebody who's an expert, some lawyer who's an expert in the construction field, can from day one, and by the way, there are 2 types of dispute boards. One is from day one, is associated with the project. So he is very in with the project. He is, from day one, he is with the contracts, with the agreements, with the negotiations. He is taken on board. So anytime a dispute, a perceived dispute arises, he can, the board can, the member can immediately highlight and avoid that dispute. And that avoidance of disputes can save thousands and thousands and probably sometimes millions of dollars for the project. Second option is, as and when any dispute arises, immediately it goes to the board and they can tackle it then and there. The success rate is very high in the entire world. I believe 12 countries in the world have are functioning with these boards, and I sincerely hope that Pakistan could be the 13th, and it will be very good for Pakistan, the economy. The cost is saved. The projects, we are all aware, the honorable judges are here. There are a number of projects in Pakistan, in Karachi, which are like, they are just huge buildings which are completed 50%, 60%, 70%, and the structures are just standing there. Just because of a dispute, and sometimes when you go through the depth of the dispute, it is a very minor matter which could easily have been avoided. So imagine 10 years back, a project which was conceived for a certain amount of money, and 10 years down the line, it is stalled after 50%. What is the cost going to be of restarting that project? With the cost of material, the cost of labor, the downstream contractors, the subcontractors are going to suffer, everybody's going to suffer. The persons who have, the consumer who has booked into the project, they are going to suffer. So it multiplies, it has a multiplier effect. So when I went through this dispute avoidance and adjudication board history, and I saw its benefits, I think I'm hooked onto it. I'm going to like do more about it, whatever I can, and I would encourage, especially Mr. Najib Haroon is here, he's the chairman of Pakistan Engineering Council. I think regarding construction, the projects of construction, maybe they can do something. And plus, not only construction, I was thinking the other day that in long term or big financial amounts which are at stake, financial institutions, our lenders and the borrowers, they can also enter into this and avoid future litigation, and if the disputes are avoided at the right time in big financial transactions. And I believe I was reading somewhere that even the World Bank has mandated in certain projects that dispute avoidance board or avoidance and adjudication board is a mandatory requirement in some of the the mega projects. So I believe that is the future, and the sooner we hook up to this train, I think it is better. So that is my take on it. Thank you.
Thank you. So there can be difficulties with phrasing and terminology in relation to dispute resolution methods. Do you have any view on how easy it is to explain dispute avoidance adjudication boards to clients? Is there some initial resistance to something that maybe sounds more complicated than it is?
The resistance you see is what I see, because in my legal profession, I meet with a number of lawyers. So the lawyers are basically the legal resource in this country. That, in the majority of the cases, is shy of dispute resolution methods and mediation and arbitration methods. And the primary focus of the primary reason for that in their mind is that it will take away our work, and we will be left without work. So I think Legal Aid Society is also working a lot with the lawyers, and they are encouraging lawyers to become mediators and arbitrators. And even in dispute avoidance and adjudication boards, there is a space for lawyers. Yes, there will be specialist lawyers. For example, in construction, there will be a lawyer who is expert in the construction field. In the financial matters, there will be a lawyer who is experienced in the financial matters. Mr. Ijaz Ahmad, like, he made a presentation on oil and gas. So in that field, there will be lawyers required. So what I would suggest of using this platform, a message to the lawyers would be, start getting expertise in different fields, because the future is of a specialization, and like mediation, arbitration, and dispute avoidance boards like this. And their source of income will be changed slightly from litigation to this. Litigation will always be there. That is, this does not mean dispute avoidance or dispute adjudication boards that there's going to be no litigation. But this is just a step before that, because time is of essence. Especially in huge contracts like construction contracts, you waste a few days, you waste thousands of dollars, your project feasibility sometimes goes out. So I think that is the message which needs to go to the legal profession, the advocates.
Thank you. And I'm conscious each of these individual talks could be explored in a lot more detail, but we're just trying to give you an introduction to all of these areas. So I'll move on, if I may, to the third speaker. So again, Mr. Bawani would be someone who doesn't need a very long introduction. He's the managing partner of a very well known namesake firm here, and I'll try and take some care to get his topic right. So if you bear with me, as you may already have seen, it looks at the effectiveness of dispute avoidance mechanisms in listed securities trading market and the mutual fund industry of Pakistan. So Mr. Bawani, thank you.
And good morning, distinguished guests and honorable judges. Now we're talking about listed securities and trading. Obviously, we're talking about the Pakistan Stock Exchange. The trading mechanisms, the trading systems, we're all well known to why it's done, how it's done. But disputes are always going to be a part of this particular business or this particular industry, however you want to call it. And that is manifold. The rate differentials, the customer claiming that this is not the rate when I said that you need to execute. I did not exactly go for financing. It was just outright buy. Clients unable to trade because of systems downtime. And most importantly, clients claiming or customers claiming unauthorized trading in their ledger accounts. So what the PSX did was that it created its own dispute resolution board, which is the PSX arbitration. Under Section 18 of the PSX rulebook, which is the regulations governing the exchange, there's a well-formed arbitration board which takes up all the disputes between the clients and its brokers and vice versa. Again, there's an appellant board as well. There is a single arbitrator or an arbitration panel depending upon its jurisdiction and a quantitative value. Now, this was a step which was very well appreciated because the majority of investors are retail sector in Pakistan in the listed securities. So if all of these disputes ended up in court, the volume of litigations would just be exponentially increasing and the burden on the courts would increase a lot more. Now, has this been effective? Yes, it's been very effective in reducing. But I'll give you some piece of statistics which actually shock you right now. In the year 2023, there were more than 300 complaints received by the Pakistan Stock Exchange regarding disputes between clients and its brokers. The more than 300, that's, I think, a reasonable number. But the shocking number is only six went up to the arbitration forum. That's it. So what happened about the rest of the 295 odd numbers? Where did that go? Now I'd like to bring the attention to yesterday's panel. Mediation is the new plague. Honorable Justice Junaid Ghaffar was on that panel, so was Ms. Naveen Merchant. I wish if that statistics would have been played over there. The 6 that went to arbitration were good. The rest were actually resolved by informal mediation being undertaken by the PSX at its own accord. They've actually reduced the burden of arbitration as well. The mediation is actually a very big success at the PSX level because, again, it's a retail sector. You don't want to burden formal dispute resolution mechanisms on the PSX arbitration and certainly not onto the judiciary over here. The PSX has to be lauded for its efforts at that front, undoubtedly. And why is it working? Because the brokers can't go against the PSX award. I mean, they are a licensed entity. If they decide to say, okay, we're not following the PSX award, it will have consequences on the license renewals. So they are bound to follow it. And of course, for the common man, the retail investors, it's a speedy justice, speedy resolution to their complaints. So the arbitration is there, it's functioning, but more importantly, mediation is the one which is taking over. Now, let's just get to the core subtopic over here, dispute avoidance. How and what has PSX done to ensure that disputes are minimalized? They'll never be eliminated. Disputes, litigations, they will never be eliminated, but they can be reduced certainly. And there have been a lot of efforts by Pakistan Stock Exchange and the Securities and Exchange Commission of Pakistan in bringing in regulatory reforms and regulatory conditions which have reduced the number of disputes. Again, 300 disputes in 1 year as opposed to 294 disputes in the year 2022. That is a very, very small number considering the volume of trades which are taking place at the PSX on a daily basis. That is a very trivial number considering the number of customers and investors we have on the PSX. So what has the PSX done? What has the SECP done which needs appreciation for that effect? Each order of the client has to be on a recorded line if it's given on the phone and a trader assistant. If it's been going through the mobile app or an online mechanism, it's already having a log. The client can't go back and say, oh, I did not place this order. This dispute that I do not own it, that is eliminated. There are day-end confirmations. Every single day, every single trade that an investor makes, he gets an email on his registered email ID that this is what you have done. If you have any problems, please raise a dispute. We will look into it right then and there. The quarterly account statements, whatever you've done in one particular quarter, has to be gone to each individual investor. And more importantly, trading can only be done through authorized individuals only, which is very important for corporates and mutual funds and all the banks where have treasury functions. Not everyone can go ahead and say, okay, I'm going to place an order on behalf of an institution. It needs to be the authorized person. Risk disclosure forms have been enhanced. The risk disclosure acceptance level has actually accepted by the clients. Payments to be made by banking sector, banking channels only, sorry, my bad. Banking channels only. It can only go from a client's account to the broker's account and no other way. The cash dealings have been eliminated altogether. And there have been separate accounts where client funds are parked. The broker cannot exactly use it. It's being reported to the PSX. There's separate reporting to the auditors as well of the company. They need to be accounted for. Is this enough? Can more be done? Of course. The majority of the disputes that come place or arise is because of private dealings between a broker and the trader. Sorry, trader and the client. They actually correspond unofficially through WhatsApp channels or their own private personal numbers, not through recorded lines, which makes it very easy for the customer to go back and say, I did not authorize these trades. The trader did it on his own. This is unauthorized trading. I am not willing to own it. And that's the biggest cause of dispute these days in PSX. So these methods are there, recorded lines and everything, but they need to be strengthened. Mobile phones are still siphoned off into the trading rooms, unfortunately. We see that regularly. But why can't we have recording facilities mandatory on mobile phones as well? We've got that facility. There's a cost to it, fair enough. The broker can accept it or the regulators can actually take it on their board because all brokers will be able to have that because of the volume. But recording on mobile phones and registered mobile phones of each trader, we can have mechanism that traders can't have more than one mobile phone. I mean, somehow there has to be a recorded facility where all trades are recorded and that there can't be no room for private and personal trading. So that is which I think an area for improvement for PSX. Now let's move on to the second aspect of which is mutual funds. It's something, again, we all know, collective investment schemes and all that. Open-end schemes, investments are being made at the market value, the net asset value of each unit. The net asset value is calculated based on the value of the investment portfolio of the individual scheme. Now, where a dispute can come in over here. Now let's break it down. If a client or a customer claims that the value of the unit is incorrect, that's not going to be very tenable. That's not a tenable position because the value is calculated as per the methodology and concepts delineated in the constitutive documents. That's not going to happen. That's not going to be a very tenable complaint. The complaint that losses were occurred due to poor fund management. Now, we're entering into a very subjective area. Was the fund manager prudent? Was it not prudent? That's subjective. The objectivity of it is, was it done in accordance with the methodology given in the constitutive documents, in the offering document, and the trust deed of the fund? If the answer is yes, then again, the dispute chances are very low anyways. The biggest dispute in the mutual fund sector. The client claims mis-selling. Now, the dynamics of the mutual fund sector is that in order to make sales, there are sales agents and distributors which have been engaged by AMCs all across the board. They go pitch their investments and the schemes to all these investors, and then they end up subscribing. The customer comes up and says, I was told that this is a guaranteed return. I was told that this particular product will give me a steady stream of income every month, and so on and so forth. So that is the biggest challenge that we are facing. The distributor and the AMC, the distributor and the client, what is being told between them, what is being shared between them, is it actually in accordance with the terms and conditions of the constituted documents? And a lot of times, it's not. And I think 99% of the disputes in mutual fund industry stem from that particular aspect only. How do we curb, again, back to the focus area, the subtopic, dispute avoidance. Disputes will take place, as I said, but dispute avoidance. What can be done to avoid these disputes? That's the biggest aspect. Now, I think the function of these these distributors and sales agent or the compensation is linked to the number of sales that they make. If they end up saying that we have made X number of units or got X number of investment in a particular scheme, they get their cut. They get a part of the pie. Let's change that. Let's align the structure of compensation to long-term goals. It's not just sales, but it's also how satisfied the client is. How long-term relationships has the client built with that particular scheme? How many complaints were received against that particular sales agent? These are the things which will help ensure that incentivize, that the overall stakeholder goals are aligned. It's not just a sales pitch that get me the sale, I get my cash and I'm out of here, and let the AMC suffer. Another aspect is risk categorization. The SECP has given forms and standardized guidelines over here that each customer at the time of making an investment needs to be assessed for his or her risk appetite. Is it a low-risk person? Is it a guy who's a risk taker? Does he have the capacity to assume a high-risk product? Risk categorization is just there for indication and for advisory, and it's generally disregarded, at least by the sales agent and distributors. It's recommended that this particular function should be outsourced to independent third parties. Specialists go on, they conduct the assessment, and they categorize the customer as risk averse, risk taker, medium risk, high risk, or whatever it may be, as far as the risk appetite is concerned. And accordingly, advisory must be given to that particular investor that you're a risk averse person, you don't have the appetite, please don't go for, let's just say, stock market fund. Take an income fund or a capital protected fund, that would be more suitable to you. So the risk categorization is something that needs to be done independently, not through the sales agent. And finally, what if a person with low risk appetite voluntarily decides to go into a high risk product? There's no law stopping that. There cannot be any law stopping that. So how do we ensure that the investor is actually aware of what is he getting into? That's a high risk product. There's a big chances of loss coming into it. How do you know that the AMC is comfortable with that? So there needs to be a separate statement, not just a generic statement, a separate statement that I am a risk-averse person, I have a low-risk appetite, voluntary for this particular investment, I'm going for a high-risk product, and I will not hold the AMC responsible for allowing me to make an investment into a risky product which is beyond my risk thresholds. That is an imperative thing that actually the customer can't go back and say, I am a risk-averse person, this was my life saving, I've lost it because of mis-selling. All of these complaints will actually reduce greatly. Now, dispute avoidance is the way forward. As we were discussing yesterday as well, Barrister Shiraz made his speech about FIDIC. We need to make those efforts. We can't have small retail investors going into arbitration or even litigations. The judiciary has a lot more serious and sinister stuff to do, and with all due respect, these retail claims can and should be handled at a very low level. So dispute avoidance clauses would really help.
Can I ask you one question, if that's okay? And
Sure.
Again, each of the three speakers so far is in a specialist area that not everybody will be familiar with. So not everybody in the room will have Mr. Ahmed's background in oil and gas, or be familiar with the Dispute Avoidance Adjudication Board model that Mr. Saki was talking about. So, Mr. Bhawani, it's maybe easier for some of us because in one way you're talking about money and money goes missing. So is there anything eye-catching you can tell us about any instances where somebody has paid money in relation to securities trading and they then claim that it's not ended up where it should have been?
I don't think that is not a very high probability in Pakistan. You see, how the trading works over here in Pakistan, when you enter into a particular trade on the ready market, the identity of the counterparty is unknown. It's just a PSX platform, it's a buy and sell order, and it's just executed by the trading engine of the PSX. Once the order has been finalized, it is taken over by the National Clearing Company of Pakistan, NCCPL. They take over and become the counterparty through novation. The legality of this particular concept of novation is covered in the Securities Act 2015 and the NCCPL's regulations, which are made as a part of the clearing company's licensing and operations regulations. So when NCCPL comes in as a counterparty, they guarantee settlement and completion of the transaction. So you can't exactly say that I did not agree to this particular trade. It's matched on the PSX engine and it's settled by NCCPL. There's no chance for someone to go around and say, no, it's not happening. And that's the same case for negotiated deal market or over-the-counter market as it's known in the UK. Again, when you place the transaction, well, you know the counterparty, it is still taken over by NCCPL for settlement. And in case there's a default, while NCCPL is doing that, NCCPL will make good such defaults through its own funds. It has a settlement guarantee fund for that. And then it will, of course, take default proceedings against the securities broker.
Thank you. So it's very, very impressive as a visitor to Karachi, as someone who's only occasionally been in Pakistan, to see the degree of support from the judicial system today and yesterday for this event. It really is, impressive, and I'm very privileged to now move on to introduce the fourth and fifth speaker, who are representatives of the judicial system. So to begin with, if I can just hand over to Registrar Chopra, who's from the Baltistan Chief Court, and the topic in this instance is harnessing harmony, risk management strategies for dispute avoidance in the energy sector. So over to Registrar Chopra. Thank you.
As far as my topic for today is concerned, the risk management as to avoid disputes in energy sector. First, to understand the energy sector, one must understand the value chain of energy sector. That is, Ijaz has already defined it, the upstream and midstream and downstream value chain. And what is the upstream? That is the exploration, that is the excavation of energy products, and the midstream, that is the manufacturing and transportation, and downstream, that is the market, pricing, and the consumers. So these three different segments of the energy sector carries different system of understanding and system of agreements that needs to understand first, and what are the requirements of these segments. For example, to understand the upstream, that one who is related to the energy sector must understand the requirements. For example, an international company or international excavation or exploration company is working in a country to explore the things, explore that segment of this sector. Not only the persons, not only the stakeholders relevant to that sector, but the states who host those companies must understand the technicalities of the contract. That is much more important. To understand the energy disputes, I would like to categorize it in two ways. One is the micro level management is to avoid the risk, and the second is the macro level management to avoid the risk in the energy sector. Not only energy sector, but in the investments, huge investments which a country or state is inviting international people to invest in the state. And what is the micro level management? The micro level management, that relates to the agreements, that relates to the clauses of the agreements, and the issues relating to that while drafting the agreement or while conducting an agreement or a project, one must understand is to avoid the disputes. Because it is very much important that while signing a contract, the company or the investor or the investate or the stakeholders must know what are the requirements and what are the international standards and what are the things that require to be keep in mind while doing on that, because no breach can take place in that particular agreement or that particular contract. And what is the macro level management? That mostly we're missing. And even I think lots of panelists and experts who have discussed on different issues relating to ADR, arbitration, mediation, but I think this segment is, I think, almost missed. And what is the macro management? The macro management mostly relates to the state's organizations. For example, who are the stakeholders in macro management? That is the state, judiciary, and state institutions, who are more important than a person who is a party to a contract, or a stakeholders who are working on a specific project. Like, for example, there are BITs, there are MITs, and there are different international conventions on the topic, on the point that requires understanding, and that requires thorough discussion, that requires deep understanding as to understand what are the BIT and what are the MIT and what are the international conventions and what are the guidelines given by the UNCITRAL, International Energy Charter. These are the instruments who gives guidelines to the states and its organization. And what are the BITs? For example, there are many cases due to violations in the BITs, state has suffered a lot. Yesterday, I think an international participant who raised a question regarding the Reko case. And he was not only interfered, but he was stopped to question. And it was avoided totally to answer. We being a responsible state, it's our basic responsibility to ensure the public interest, to ensure the state interest. How we can cater with all these situations when it comes in our way towards economic progress. Because the most important thing to bring investment, we have to satisfy, we have to build the trust of the investor in our country. What happened in that particular case, for example, there wasn't a BIT between Pakistan and Australian government. And the TCC was the stakeholder. TCC explored in our region. When exploration was completed, the license was denied. The matter was before the Honorable Supreme Court of Pakistan, and even Honorable Supreme Court of Pakistan issued a judgment and declaring it void. The agreement was totally void and it was totally against the interests of the people of Pakistan. It was challenged before an international arbitration forum, and very unfortunately, we could not defend the case before international arbitration forum. And it is the worst case in the history of the arbitration and the world of the arbitration, because the fine imposed on Pakistan was the heaviest one in the world. It is not only worse because there was a fine in Pakistan, it is worse because this case is being discussed in international universities. And it's a case study for the students. And even it was the same case study for me as well, because how it happened. There are several questions. Some of the speakers very rightly pointed out that yesterday that the BITs, that the international agreements must be regarded. I'm talking because the energy sector is one of the biggest sector, not only in the world, but for Pakistan as well, because we are facing energy shortages. So we need to avoid, we need to do drastic things and bring changes is to streamline the system. Because the most important question was in this case, the BIT. Whether the BIT was not understood by our experts, whether it was not properly understood by our government. It was a question because it was agreed. When their BIT forms, when the expert sits to make a BIT or MIT, their international legal brains are involved. There are very tricky issues are there. We need to understand that. For example, before thinking to bring a change in that system, we need to know what are the clauses of the BIT. For example, it is an international standard that there are some clauses which are by default in an agreement or in a BIT. What are those clauses? For example, there is a freezing clause always. What are the freezing clauses that needs to be understood, and we need to focus on that. The freezing clause is always there when any regulatory change brings in the country, then the protection is given to that investor state or that investor company in a state. If we violate that, and by violating that freezing clause, if we expropriate either direct or indirect their assets in the country, it's a big and huge violation of BIT, and that's a big and huge violation of the agreement. Ultimately, that causes disputes either in arbitration forums or for litigation. It opens doors for disputes. So what is expropriation? Expropriation is, for example, one company or one country, one investment country, who is invested to explore in a country, and we finally declares that agreement null and void, like in the recorded case, it becomes an expropriation, which is forbidden by the international law, forbidden by the international standards and BITs and agreements between the parties. So we need to keep these things in mind. To avoid these things, for example, His Lordship Jawad Hassan Saab, he was focusing and stressing on the new arbitration laws in Pakistan. These are the things to develop the confidence of the investors in the country, no doubt. But simply changing the law or simply bringing the Arbitration Act in the country, it will not solve the issue, it will not serve the purpose. Why? Because we need to align all other related laws. Those are the contract law, the civil procedure law, the evidence law, and at the same time, we need to bring drastic changes in those laws as well, so that we could align ourselves to the international standards. Look at our contract law, for example. What do you think? Whether existing contract law meets the requirements of the international standards, whether it meets the international advanced law of obligations, what other countries are following? Absolutely not. When the expert sits and that discusses about the legal systems, because there is a concept, the choice of law concept for the investors when we are drafting an agreement, they will not prefer Pakistani law, because when you look into the matter, when you study our judicial system, our law, contract law, it falls nowhere. Neither it is a common law concept, nor it is a civil law concept. It is still purely a colonial law, because the modern world has developed their own jurisprudence in the contract law. They have ideas, they have concepts, they have definitions, they have interpretations. When an expert sits and discusses the different systems of laws, they will not prefer Pakistani law because they doubt on our legal system. They doubt our interpretations because in modern countries, in modern developed countries where economies prevails, they have their own jurisprudences. They have their own perspectives while interpreting a law. For example, there is a Western perspective, there is an Eastern perspective, there is an English law perspective, there is a Canadian law perspective, there is Singaporean law perspective, there is a Chinese law perspective, judicial perspectives. But very unfortunately, when we discusses on our judgments, our laws, every single judge, honorable judge, has his own perspective. So we need to streamline all these things to avoid these type of international disputes. I'm not talking of the micro level disputes that normally people faces in courts, in ordinary courts. We need to establish proper professional commercial courts according to the international standards. Unless and until we do not that, I think it's really not possible for Pakistan to attract the international investors into Pakistan. For that, to avoid these type of disputes at international forums, at international level, we need to train our judges of district judiciary. We need to train our lawyers of district judiciary. We need to provide them opportunity to study abroad. When you go to the different countries who have developed, when we sit together with the judges, I think I got an opportunity to visit Singapore. I saw every single civil judge or district judge who were graduated from Oxford and Harvard and international renowned universities.
I'm really sorry for interrupting
Thank you so much. I'm very sorry.
Talking of judges, we're still to hear from a judge on this panel. So if you forgive me for not asking you a question, if I can hand over to Judge Anwar. So I just checking if Judge Anwar was...
Thank you so much.
Thank you. I was just checking if Judge Anwar was staying where he is, or if he wanted to speak from up here. And Judge Anwar is, as you all probably know, from the Peshawar High Court, and he's talking about integrating dispute avoidance in Pakistan's court system. So over to the judge. Thank you.
I will read from the note prepared in the morning, and thereafter, if there are any questions, I'll try to answer the same. In order to avoid lengthy, expensive, stressful, and agonizing litigation, alternate dispute resolution has since long engaged the attention of the civil society. Various modes and techniques has been adopted and followed for dispute resolution from time to time. For example, direct negotiation without the intervention of any third party to settle a dispute in an ideal mode, leaving all the parties happy with the outcome of such amicable settlement. Mediation, consultation, conciliation, and arbitration are some of the modes engaging third-party intervention of appointing neutral persons to bring about settlement of dispute at local levels. All of us must have heard about panchayats in Punjab, Fasilo or Sulh in Sindh, and Jargah system in Khyber Pakhtunkhwa and Balochistan, which are still being considered as powerful institutions in our local system. Though such modes have no specific statutory backing, their verdicts and decisions are used to be accepted and considered as binding. I will now refer to some of the laws, mainly in our province. Firstly, by the Britisher, that was FCR Regulation 1901. If the provisions of that FCRs are gone through, you will find that the decisions on criminal as well as on civil cases are required to be first referred to the jirga, and that was in fact the mediation or the conciliation at the relevant time, and whatever the jirga that has decided, that it was then referred to the political agent, and such political agent either has to endorse the same or refer to a second jirga. In 1961, conciliation court ordinance were promulgated, providing conciliation courts for this purpose. If we look to the provisions of family laws, there are pre-trial and post-trial conciliation proceeding, and the main intention is that the issue, if any, between the parties is decided without the further intervention of the court. Similar provision were introduced in Industrial Relation Ordinance of 1969, providing for conciliator in the industrial disputes and also a shop steward who was intermediary between the worker and the employer. Addition of ADR provisions were made in the Income Tax Ordinance, Customs Act, Sales Tax Act, Federal Excise Tax Act for encouraging the resolution of disputes. And also insertion of Section 89A in the CPC, and in fact these steps or these legislation that were made by the government. Now I'll refer to a very good law that was promulgated in our province for the area of Malakand division, which was named as provincial administered tribal area in the constitution, and due to certain revolt by the local people against the civil law promulgation, Sharia Nizam-e Adl regulations were promulgated, and the last in such lands was Sharia Nizam-e Adl Regulation 2009, which is still enforced in the Malakand division. In the said law, section 3, I will quote, any civil or criminal case subject to mutual consent of the parties may be referred to muslih or muslihin. And different notables and religious scholars were notified as muslih, muslihin, and that list was maintained by different civil courts. For the timeline of 15 days only was given for such decisions. Unfortunately, inclination toward the decision through muslihin has been thwarted, and the ultimate sufferer are the poor litigants. Due to paucity of times, I am thankful. I and our brother judges feel to have been benefited from the opinions of the expert in the conference, and would certainly share these views in our High Court for appropriate rules making and also for the implementation of the ADR laws, inshallah. Thank you for the patient hearing.
Thanks again to the panel and to the audience. Thank you.
Thank you.